You might think constitutional lawsuits work like this. Find an unconstitutional law, challenge it in court, and if the law is truly unconstitutional, the court will strike it down. But in reality, a web of legal doctrines and ingrained attitudes mean that judges have enormous leeway to avoid ruling against the government. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. We're talking with IJ attorneys Josh Windham and John Wrench on judicial deference and why courts protect some rights better than others. This is Beyond the Brief. So people hear a lot about judicial activism, and maybe we should even just talk about what that is. But then can you, in general, sort of expand on how do judges usually approach cases against the government?
Yeah, I mean, judicial activism is making up the law as you go according to your personal policy preferences. And I think the big concern with that is that the judges aren't applying the law as they find it. They're kind of making things up as they go and injecting their own, preferred outcomes and solutions into the judicial process. And so that's the basic problem with judicial activism.
And on the kind of the other side of that is judicial deference, which is really like a lens of how some courts view really their role when they're reviewing what the other two branches are doing, when they're reviewing challenges to the constitutionality of laws or executive actions and things like that. And judicial deference is really a view that the court should, in many situations, yield to or facilitate what the government is doing instead of being kind of a citadel in between the government and people's individual rights. And the problem with that view, just like a judicial activism is kind of on one end of a problem, the problem with judicial deference is that it's just kind of naturally incompatible with the design of our constitutional system. And so, one of the people who helped design that, Alexander Hamilton, wrote in Federalist 78 that the courts are supposed to be citadels of public security and justice. And he says that that will really collapse if the courts ever unite with the other branches. And I think that you can really understand judicial deference as that unification with the other branches instead of defending people's rights.
And deference itself is of somewhat modern vintage. I think historically, and of course painting in broad strokes is always difficult with history, but historically it was viewed as a sort of reaction to what was seen as a judicial activism of the 1950s and the 1960s. The Warren Court, and there was this sense that maybe judges were going beyond their role, and so then you kind of had a reactionary movement with deference. Is that right?
I think the reaction to judicial activism goes back to the early 20th century and sort of the way that courts were grappling with the Great Depression and the New Deal. You had this so-called Lochner era in the early 20th century where courts were taking seriously the right to earn a living and what it called liberty of contract at the time, and striking down economic laws that didn't meaningfully further any legitimate governmental end. The famous Lochner case involved a restriction on the number of hours bakers could work in a week, for example. And over time, the Lochner era started to fade away when we had economic crisis and we had, people from all over the country caterwauling about how we really needed, rigorous economic regulation and kind of top-down control of the entire economy. And courts were getting in the way of that. And so we had kind of a backlash where in a case called Caroline Products, all of a sudden the U.S. Supreme Court said, we're going to flip this. We're not going to take economic regulation seriously and give it meaningful judicial review. Instead, we're going to give it what we're now calling rational basis review, which is where we give the government every presumption of validity when it's restricting economic activity in various ways, statutes, regulations, or otherwise. And in the famous footnote 4 of that case, which I'm sure some folks are familiar with, the court then started to divide up our rights into different categories. So you have rights that are not enumerated in the Constitution according to the court, like economic freedom. And then you have other rights, like those that are listed in the Bill of Rights, the rights of, quote, discrete and insular minorities, and the rights to engage in the political process, for example, political speech and voting. And the court says, well, those rights we're going to give real judicial review, strict scrutiny, as it later became known. But for economic regulation and these kind of unenumerated rights, economic liberty rather and unenumerated rights, we're not going to give them meaningful judicial review. We're just going to give them rational basis review. And that all kind of reached its apex around the mid-20th century in Williamson versus Lee Optical, which is sort of this huge, height of deference the court was giving economic laws and saying, if as long as there's any conceivable rational basis for a law, however fanciful that might be, even if the law is wasteful and needless and harmful in some ways, that's fine. We're just going to rubber stamp the law and not get involved.
So the thing that seems sort of circular about that is when you're saying, these rights that aren't explicitly enumerated in the Constitution get less protection, there's a thing in the Constitution about how that shouldn't happen, right? And so how do you kind of reconcile the Ninth Amendment with anything that's going on here?
Yeah, I mean, I think that it is basically impossible to reconcile it textually, and this is kind of a result, this reading things out of the Constitution, I think was a result of this process that Josh was describing. And I think if you go back to Lochner itself, there's 3 opinions in Lochner. And the majority opinion, looks at this maximum hour law and says, we don't think that there's enough evidence here that this is actually based on health and safety concerns. We think that this is actually kind of a protectionist law. They say that they think it's a labor law that's been disguised. And so they think that there's not enough evidence, and they strike it down. They say it violates due process. The first dissenting opinion, and this is kind of like sets up the issues about deference and engagement and activism later, is the second opinion, a dissenting opinion by Justice Harlan. He looks at all the evidence. He says, I think I just disagree. I think that there is enough evidence here to show that this is a health and safety issue. And he goes through that evidence. What he's essentially saying is like, I'm looking at the evidence. I also care about it, but I'm coming out the other way. And I think we should probably lean more towards a presumption that things are constitutional. And then there's a third opinion, which is written by Justice Holmes, which is today by far the most famous of those 3 opinions. And it is just Justice Holmes alone dissenting. And he basically is suggesting that they do something radically new. He has a hot take. And that hot take is that courts should basically get out of the business of looking at these kinds of regulations and weighing them and looking at evidence. He really, and this is in the background of kind of a lot of the judicial restraint philosophy, is maybe majoritarian politics should basically dominate. Maybe the court should have a lighter hand. And even though this case involves a maximum hour law and economic regulation, Justice Holmes actually thinks that in general, courts should probably be out of the business of doing this. And that's not directly connected to unenumerated rights in the Ninth Amendment, but I do think that the framework, this way of looking at the Constitution as, is it really my job to interfere with what the other branches want to do? I think a lot of that is what led courts to do a lot of things that are criticized nowadays, like reading the Ninth Amendment out of the Constitution, like a minimal reading of the Privileges or Immunities Clause. All of these things are kind of results of this more Holmesian refusal to get involved and be the citadel that Hamilton kind of expected.
And this,
courts
to be clear, I think a lot of this comes from. There's a nod in the way that Holmes is talking about. One of the quotes that I think sticks out in a lot of people's minds, I don't know if you have it committed to memory, John. I barely do. It's the line about how the word liberty in the Constitution is perverted when it's construed to mean, preventing the outcome of a dominant opinion, right? Mm-hmm. Something to that effect. And, that's the opposite of what liberty means, right? Like liberty is all about your freedom to act without the kind of restraint that was at issue in the Lochner case and other cases. And so, for Holmes, his view is like, well, the will of the people is expressed in this statute, and what role is it of mine to strike it down? And the answer is, for all the reasons John just gave, it's every constitutional duty of yours to strike it down if it violates the Constitution. Yeah,
and one of the kind of bizarre things that results from this is you have some folks after Holmes who do really believe in this like judicial restraint where the court really shouldn't be getting involved at all. They kind of want something like legislative supremacy, which is, of course is not our system, but you can kind of fiddle with separation of powers to get there. And then you have people who, as time goes by, and this is, you get to Caroline Products and you start to see this. This is the footnote that Josh was talking about, where now there's these tiers of rights. Some of them get real protection, some of them don't get so much. And I think that's a consequence of people dealing with kind of Holmes's view and saying, well, I don't know if we actually don't want to protect everything. Maybe there's certain rights that we actually do care about. Maybe there's certain rights we don't care about so much. And things like economic liberty, the thing that was at issue in Lochner, and plenty of other rights, basically got swept into rational basis review, which is this very, very weak level of review, and other rights that the court has decided actually matter get meaningful scrutiny. And there's no basis for that in the Constitution.
I want to talk about tiers of scrutiny in just a minute, but before we do, John, you said something earlier. You mentioned, deference, activism, and engagement. I know engagement is a big buzzword here at IJ. It's something that we care about a lot. I know that you work with our Center for Judicial Engagement. Can you explain what engagement is and how it kind of falls in the spectrum between deference and activism?
Absolutely. So earlier I was kind of mentioning that the way that you can view judicial restraint is when courts are yielding to or facilitating what the government is doing instead of being a citadel. And, by design, the judicial branch is independent. They have life tenure. The judicial branch was designed so that across time, it could be deliberative. It could look at constitutional principles. And although, of course, there is always political influence to some degree, and justices are people, it is certainly the most independent of the branches. And so that's useful because in times of, political chaos or turmoil or anything that's, problematic socially, the court is in a position to actually be concerned about the longevity of constitutional rights. And this is where we get into engagement. It's taking seriously that role across time. It's looking at when plaintiffs bring a case against the government, for example. It's looking at evidence seriously. It's looking at the government's actual justifications for laws. It's not inventing new doctrines or arguments to try and help the government out of a situation that it has gotten itself in by doing something unconstitutional. And so, in essence, it is between these two, you could view them as kind of judicial vices of activism, this overreach or this restraint, a refusal to get involved. And I think that one thing that people can kind of forget, depending on where they're on that spectrum, for people who are very concerned about judicial overreach, what they often don't grapple with is that you can make an error by not acting as well. And that's the same for people who are concerned more about judicial restraint is. You can make an error by not acting when you're responsible for doing it, or by acting too much when it is not your responsibility. And I think that judicial engagement is about framing courts in that way where the Constitution designed them to be.
And I think we talked a little bit about like kind of what deference is at a high level, but it shows up in like really concrete ways in some of the cases that we litigate and cases that others litigate as well. And I think I can think of three forms of it. I mean, maybe John has others, but you've got legal standards that apply when someone is challenging government conduct, right? We've talked about rational basis review being the most deferential and difficult to overcome. That's a form of deference. We've got procedural or technical off-ramps that courts might take to avoid even reaching the constitutional question at all. That's another kind of deference, right? And then we've got, I think, the court's like general Holmesian instinct that comes out at times where we just say, look, the government action here is expressive of the will of the people, right? And so who am I to kind of get involved at all? And so it's almost like a meta level of just looking for ways out of having to do the hard work of saying, you know what, the government did cross a line and I have to enforce the Constitution here.
Can you give an example specifically in the sort of rational basis context of something that a court has done to sort of bail out of a case that it otherwise should have kind of been more engaged with?
Yeah, I mean, IJ had a challenge a number of years ago to Floral licensing in Louisiana, which was quite literally a requirement that if you wanted to sell flowers for a living, bunched up in a bouquet, you had to get a license from the government to do that. If that sounds crazy to you, it's because it actually is kind of crazy. And the issue is that when we got to a federal district court, the court came up with a justification that said, well, I can conceive of the fact that somebody might be dealing with infected dirt when they're selling somebody a bouquet of flowers, and that infected dirt could, cause them to get ill and maybe they'll die. And so that's a potential rational justification for requiring somebody to go take a test and, arrange bouquets in front of their future competitors to get a license from the government just to sell flowers that you could pick up off the street. And if you are somebody who thinks that that's not a totally fanciful justification for a law that restricts somebody's right to earn a living, like, you're living in judicial deference land. This is how courts think about this.
Yeah, I mean, you could maybe get there if the test includes a whole bunch of, you know, oh, you have to do all this science with the dirt and make sure it's not infected and then do these 12 things or whatever. But it isn't that at all. It's just a completely subjective, are your flowers pretty or whatever.
Part of what made the test so burdensome is, again, that you had to, it was a practical component to the exam where you had to actually arrange bouquets that were judged by your future competitors. Like, that's how it worked. And that has nothing to do with keeping people safe from infected dirt, such as it is. That's a lot more about giving the industry incumbents the ability to fence out new competitors, which did have a lot to do with a lot of the early laws that were struck down by the Lochner era courts. You know, a lot of them did have their basis in protectionism.
Yeah, and I think it's helpful to frame exactly how insane it is to tell courts to deny reality, because that's kind of what you get when you're at this like apex of deference. I mean, imagine that your favorite sports team is playing in a championship and you see an incredibly heinous, obvious foul on your star player. It's a play that could have won the game. And the referee comes out and the referee says, well, you know, I saw it too. You know, I did the review. I saw what happened. But, you know, I'm not sure that my job is really to interfere with the game. You know, we're going to kind of let it go. And everybody saw what happened. The person who committed the foul saw what happened. The person who committed the foul doesn't even make an argument that they should get off free. And the person who's refereeing that just kind of decides not to say or acknowledge what happened. And I think that that's what you get at this peak of deference, is you have actually created a doctrine that requires courts to deny reality and conceive of things, which basically means that at the end of the day, you can lose a rational basis challenge so long as courts can come up with the most fanciful thing possible.
And in that context, though, there's often a call from the audience to let the players play, right? You're getting in the way of the game. This is not a game. This is people's constitutional rights. And if you tell somebody that they can't earn a living, like, that's going to affect their ability to live, right? And so the stakes of these are really high in a way that the stakes of maybe a football game are not.
Speak for yourself. There have been some times as a football fan I've been on the wrong side of those calls, and I think a lot of people listening and who also appreciate sports as I do, I think would probably react with the same outrage. And I think that's the outrage that we have when we try to litigate these cases, and the people who are responsible for, enforcing the rules as they're written decide, well, that's not my job today.
And, the issue with this kind of deference, too, is that it does present a kind of separation of powers problem, because the way that the most deferential courts will approach it is to say, well, if we can conceive of any plausible justification for the statute at issue or the regulation that's being challenged, then that's the end of our inquiry. But the way this conception often works, this imagining often works, is that as a judge, you're putting yourself in the mind of the lawmaker, and you're saying, what facts could they have thought they knew, right? Which is just a way of saying that courts are doing legislating, right? They're putting themselves in the shoes of legislators and trying to imagine what they had in their minds. Like, that is not your job.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
John, this might be a good juncture. We've been talking a lot about any possible rational justification for the law. I think the three of us recognize we're talking about rational basis. Someone who's listening or who's watching might not understand these different tiers of scrutiny. I know you mentioned earlier that they're nowhere in the Constitution. Could you kind of give us a brief overview of what you're talking about when you're talking about tiers of scrutiny and where rational basis kind of fits into all this?
Right. So as a result of the footnote in Caroline Products that Josh was talking about, where the court says and starts to suggest, well, maybe we're going to deal with different rights differently. We're not going to, give no review to all rights. We're kind of concerned about this hyper Holmesian approach, but we're certainly not going to thoroughly protect everything. And so at that point, the court is starting to come up with this framework that ends up being what we call the tiers of scrutiny. And that's roughly 3 tiers. There's some modifications depending on like what area of law you're dealing with, but there's roughly 3 tiers. What you might call the most meaningful form of review is called strict scrutiny. And strict scrutiny means that the law is only going to survive if the government has a compelling interest, that the steps it's taken are necessary to achieve that interest, and it's narrowly tailored to doing so. Strict scrutiny is quite powerful in the sense that a law that's being reviewed under strict scrutiny often is not going to survive, or at the very least, the government is going to have quite a burden. Mm-hmm. And so there's a certain set of rights that the court has separated into the strict scrutiny bucket. And so if you go into court and you're complaining that one of those rights has been violated, you're going to end up in strict scrutiny land. There's intermediate scrutiny, which is kind of a middling form of scrutiny. There needs to be an important government interest, and what the government is doing is substantially related to that interest. It's kind of a mushy standard in some sense that you know that it's not strict scrutiny, but you know that it's not rational basis scrutiny. It's something in between. It's at least some form of meaningful review, though. You're not going to get that hyper deference that we were talking about before. And then you end up in rational basis, which is the government just needs to have a law that's rationally related to a legitimate government interest. And if you're thinking about the language of that test on its own, and you're thinking of Caroline products on its own, and you don't have everything that happens over the next 30 or 40 years, you could imagine winning under a test that says, yeah, what the government's doing needs to be rationally related to a legitimate government interest. Rationally related sounds like there's a standard there. Mm-hmm. It sounds like evidence matters. Legitimate government interest sounds like there's a standard there. The government needs to be doing something that it's supposed to be doing. The problem with rational basis scrutiny is in cases like Williamson versus Lee Optical and later FCC versus Beach Communications, this case that introduced the idea that it can just be conceivable, what we not jokingly call conceivable basis review. It really is. It transforms the rational basis test into what one of the justices in FCC versus Beach said, no review at all. And so those are the problems with the tiers of scrutiny. And then, back to this idea of separating out enumerated and unenumerated rights. The problem is that courts, through that kind of modification of the tiers of scrutiny, they basically read some rights out of the Constitution and amped up protection for some rights. And there's really no basis for doing that.
Yeah, Can you talk a bit about, you mentioned that the rational basis test, it sounds like a real test. It sounds like there's some scrutiny involved there. It sounds like there's, some evidence involved there. Can you give an example of a case where that test kind of worked the way that we want it to work?
Yeah, so an example of that would be, and just for some context, IJ was founded in 1991. And at that point, from the New Deal to the time that IJ was founded, no federal courts had struck down an economic regulation under rational basis scrutiny. That's a long time. And so that's kind of the legal war you're going into if you're going to be fighting a rational basis case. And in 2012, though, IJ represented a group of brothers at a monastery in Louisiana. They were taking wood and carving it into caskets, which they were selling to people for significantly less money than you would be able to buy from like a funeral director. Caskets are quite expensive from a funeral director. The problem in Louisiana is it was illegal to sell caskets, which again are a wood box that you put a deceased person in.
Just a box.
Just a box. It was illegal to sell these boxes unless you had a funeral director's license. Now, who do you think really liked that law? Probably funeral directors, right? So funeral directors wanted this law. This was a protectionist law, obviously.
And to become a funeral director, you had to, learn embalming. You had to learn all these sorts of things that these monks didn't even want to do, right?
Right. And you had to have an embalming studio, all these things that clearly are attached to, well, we want you to have to be a funeral director. We don't want to be competing with people who are just making and selling boxes for less money. And so we represented the brothers, and we got to the Fifth Circuit, and this case was litigated under rational basis. And again, in that context of not having won any of these cases in a very long time, but the Fifth Circuit actually took the rational basis test seriously. It said that the government needed to have a rational basis and that they're actually achieving a legitimate government interest. And they said that evidence just isn't here. They didn't do work for the government. They did not invent arguments for the government. And what the court said in that decision is that courts are not supposed to be blind to what's going on. This is back to this concern about the rational basis test, essentially requiring courts to deny reality. And the Fifth Circuit said the rational basis test does not require courts to deny reality. And so they ruled for the brothers, and they were able to keep making caskets and selling them to people.
So the rational basis test, we've been talking a lot about sort of economic liberty and economic regulation. But the rational basis test also gets applied in a lot of other contexts too. Can you explain what that looks like in a property rights kind of case?
Yeah, it comes up a lot in zoning, for example. So if you're somebody who's, got a commercial property and the city has said, well, this type of use is not allowed in this zone. So therefore you can't, use your property in the way that you hope to use it. You've got to get approval from the local zoning commission or whatever, and you've been denied. And it's a use of property that for you, whether it's having guests over overnight, whether it's charging people to run like a bed and breakfast, all sorts, you could imagine any use of your property where you would be, not really harming others around you. But for whatever reason, the city says, well, your property isn't zoned that way and therefore you can't do it. If you're going to challenge that restriction, that's going to trigger rational basis review as well. I mean, the courts typically lump economic freedom issues and property rights issues into this same kind of bucket because it all kind of involves questions of what the courts call substantive due process or sometimes equal protection. But all of that triggers what we call rational basis review. And so the standard isn't going to be meaningfully different whether you're challenging a restriction on your right to earn a living or a restriction on your ability to use your own property.
What happens when economic liberty and some other right that would get strict scrutiny intersect? Like speech gets strict scrutiny, but what happens when someone is, doing a job that is just speech? Does it get strict scrutiny? Does it get rational basis? What do courts do there?
Yeah, so if you're trying to bring the strongest claim in a situation where someone is earning a living through their speech, you would bring the speech claim, which theoretically would get you in the strict scrutiny bucket. The problem with that is because courts have gotten so used to kind of lumping together things like anything that you would associate with economic rights, what you often see is that although there is a speech claim that should get strict scrutiny, there's been a period of time, and especially in U.S. Supreme Court history, where the speech claim has gotten watered down. And so that's especially true in areas involving occupational speech. That could just be speech where someone earns a living by speaking. It could be commercial speech, which is situations where someone is proposing a transaction. And in those situations, especially lower courts had invented doctrines to basically make the review much more like something like rational basis than like strict scrutiny. And so an example of that might be in occupational speech, there is a period of time where courts were essentially saying there is a separate category of speech called professional speech, and if you're engaged in professional speech, that's not really speech. You don't get strict scrutiny. You actually get some other weakened form of review. And we had a problem with that because speech that you earn money for is still speech, is protected under the First Amendment. And so, for example, we represented a group of people in D.C. who give tours in D.C. D.C. made it illegal to give tours without a license, and we challenged that under the First Amendment, and the court said that does not survive review, and they struck down the law. And it took quite a bit of time. It actually took until 2018 for the U.S. Supreme Court to say the professional speech doctrine does not exist. This is actually speech. And so that's one of the common things is that you see is when you bring a speech claim or really any other kind of claim that gets heightened review, if it even smells a little bit like an economic right is in there, sometimes you'll see courts kind of dilute the strength of the claim. And so that's a lot of what we fight back
That's
against.
true as well, not just for professional speech, but also what we call commercial speech, which is speech that proposes a transaction, right?
Like a sign or something.
Like you're advertising, that kind of thing. And even there, the courts will say, well, yeah, it's speech, but seems to involve money. And that's suspect. And so we're gonna reduce the level of protection below what's typically going to be strict scrutiny for most speech claims. And that, I think, dates back to this kind of like New Deal, Great Depression era of courts wrestling with the idea that, if the government can't regulate the economy from the top down, that's going to present problems, and courts shouldn't be in the business of preventing that. And so even in contexts where speech is involved, if it seems like money is at issue or economic activity is at issue, courts start to look at that with a sideways glance.
We spent a lot of time talking about tiers of scrutiny. I know, Josh, earlier you mentioned the other forms of deference that government often get and that we don't when we're litigating our cases. And I think you've experienced that recently in Virginia Open Fields. Could you talk a little bit about that case and how that is a good example of the sort of other deferential treatment that the government often gets?
Yeah, sure. I mean, to set the stage a little bit, the Open Fields Doctrine is a U.S. Supreme Court doctrine that dates back to the Prohibition era. And it basically says that under the Fourth Amendment, people's private land doesn't receive any protection from unreasonable searches, typically warrantless searches. And that's a big issue because, there's 1.2 billion acres of private land across the country. That is exposed right now to warrantless searches under the federal Open Fields Doctrine, according to an IJ study that came out last year. So it's an expansive doctrine, but what we've started to do is to go into state courts and say, well, whatever the U.S. Supreme Court says about the Fourth Amendment, your state constitution can reject the Open Fields Doctrine. And so we launched a case in Virginia about this issue. Our client is named Josh Highlander. He owns a residential property with a few acres of wooded land right behind his house that he uses to hunt. He has a food plot there. Food plots are legal in Virginia. It's just a way of feeding animals by planting crops. And what the state game wardens decided to do was to target his family that day. So they raided properties owned by, or managed by his dad and his brother, went onto those properties without a warrant, roamed around, looked for evidence of crime, and then did the same thing to Josh. They parked in a residential cul-de-sac right behind his house. They put on camouflage outfits. They raided the property, walked past his no trespassing signs, took a camera from his backyard, basically, and then downloaded all the photos from the camera and have been sifting through those and holding on to them. And so the question in the case that the Virginia Court of Appeals recently resolved was like, one, is this even properly before the court? Like, can the court decide the question of whether this was constitutional? And two, if it can, did you state a claim that it was unconstitutional, right? Mm-hmm. And the court basically dodged all of the substantive constitutional questions that matter in the case by saying, well, yes, you alleged in your complaint, and we have to assume it's true, that they have a statewide policy and practice of doing this. Yes, you alleged they targeted your whole family that day. Yes, you alleged you were engaged in legal activity by planting a food plot. That's perfectly legal in Virginia. And you were targeted for engaging in legal activity. And yet we don't have authority to resolve this because it's pure speculation. They're going to do it again to you.
Goodness.
And so this is the idea that a case maybe like isn't ripe, which is the technical term for this. But it's just a way of saying, yes, they punched you in the face once, but how do we know they're going to do it again? Right. And the court should not be in the business of looking for excuses not to resolve live constitutional questions. I mean, our client, Josh, is afraid to put a camera back out on his property again because they could just come and steal it again. Right. And so his use of the property has changed because he's now living in fear of these kinds of raids that he couldn't have predicted before and can't predict in the future. The government claims the power to do this, and the courts say, well, let's throw up our hands and say, how do we know it's going to happen again?
So we've just heard a lot about the problems of judicial deference in the context of the suits that we file against government. I know that IJ created our Center for Judicial Engagement in part to combat this. And we've been fairly successful in that over the years. John, could you talk a little bit about what our Center for Judicial Engagement is, what we've been doing, and how we've been, moving the ball in the other direction to make courts more engaged?
Yeah, absolutely. So the Center for Judicial Engagement really is about educating courts, attorneys, law students, the public about the proper role of courts in the ways that we've all been talking about, actually caring about evidence, not giving the government a free pass when it does things that violate people's rights, to be independent and to act as that citadel of public justice that I was talking about before. And we do that through various things. We do it through podcasting. We do that through scholarship. And a lot of that, I think, has resulted, obviously, in tandem with our litigation, which we're paired with, is that, you have these problems that you see in terms of judicial deference, but you've also seen things developing in positive ways as well. Like we've seen victories in state courts, for example, who have chosen not to go this route of judicial deference and to actually apply a rational basis test, judicial review in a meaningful way. There's a couple examples of that. For example, there was a case called Patel where IJ represented eyebrow threaders in Texas, and they were not allowed to do eyebrow threading unless they got a license, they go to cosmetology school, take hundreds of hours of training that have nothing to do with eyebrow threading. Obviously, that is an irrational law. It is arbitrary, and it's a restriction on their ability to earn a living. And instead of following this hyper-deferential federal standard, the Texas courts actually applied meaningful review. And so that's a great example of courts doing that. We had another victory in Georgia where IJ represented people who wanted to be lactation consultants. They wanted to help educate women about breastfeeding and things related to that. And it was illegal to do that in the state without a license. And again, there, instead of following this kind of hyper-deferential view where evidence doesn't matter, the court engaged with evidence. They cared about applying their constitution, and they did so in a way that broke with this federal standard. So I'm optimistic that those things are working. The law often moves quite slow, but a lot of the kind of the ammunition for much of this revival is actually predates, like the bad cases that we've been talking about, where this kind of started. There's a lot of these early cases from 1910 to the 20s, where courts were involved in this kind of serious judicial review in cases like zoning or economic liberty, and the sky did not fall. On the contrary, people were actually protected more thoroughly. And I think it's fair to say that there's reason to be optimistic that we're turning back slowly towards courts actually seeing the consequences of this hyper-deferential view, and we should kind of kick it out the door as soon as we can.
Josh, to sort of wrap up, on the litigation side, how do you see this sort of unfolding into the future? What do you think is next here?
Well, I think that in both federal and state courts, we are forcing courts to grapple with this question of, in the federal context, what does the rational basis test really mean? Is it truly a test that allows judges and courts to imagine justifications for laws and to wish away evidence before them? We say no, and we've had some success, not just in the Monks case, but also in a case before that called Craig Miles, and some district court decisions, like one involving hair braiding licensing, for example, and more recently in cases involving, homeless shelters, right? And restrictions on those through the zoning process. We had a victory in North Carolina not too long ago in a case called Catherine H. Barber Memorial Shelter. And so I think we're optimistic that we can continue to win cases in federal court under the rational basis test and to push courts to treat that test as more of a meaningful test as opposed to a meaningless test. And in the state court context, we are able to paint on more of a blank canvas and say, look, whatever the Supreme Court says about the federal Constitution, you guys don't have to do that kind of deference here. Economic liberty can mean more here, and you can apply a more meaningful form of review. Sometimes that's going to look like some of the cases that we win in federal court, but other times it might involve different language entirely. Like the Patel case didn't involve a rational basis test, right? It involved questions about, is the law overly burdensome or oppressive on somebody's right to earn a living, which is just a different question. So I'm optimistic.
So thanks, guys, so much for coming in and talking with us.
It's great to be on.
Yep.
And thanks to all of you for watching. If you would like to learn more about our work protecting constitutional rights, you can like and subscribe to this channel for more videos. And if you want to support our work, you can join IJ's more than 12,000 supporters with a gift of just $5 a month at ij.org/monthly.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.